I'm Gerrit Hornung. I'm a professor for public law, IT law, and legal informatics at the University of Passau, Germany, and also speaker of our interdisciplinary institute of IT security and security law. I organized this panel together, as you've seen from the program, with Caspar Bowden, and unfortunately Caspar needed to step out on very short notice on personal grounds. So everybody of you who knows a bit of Caspar knows that it's impossible to replace him. So we decided not to replace him on this panel. So if you don't mind, I will both chair and moderate this panel. And I hope that not too many of you will now leave because they're only here because of Caspar's refreshing and provocative ideas. We want to follow up on discussions which we had throughout the last 1.5 years on the Snowden revelations and on intelligence agencies' internet surveillance. On the very last notice, Caspar and I decided to stretch the discussion to the recent events in France as well, as our current and prospective discussions on the topic will be highly influenced on the upcoming discussions on internet and other forms of surveillance as well. And that led to the feeling that we'll face a new round of surveillance measures as well, and looking at the discussion on encryption that looks a bit like the undead are now walking around again. So I'm very happy that we have this very distinguished panel up here, which I would like to introduce to you. So in the order of appearance, actually, we first have Eleni Kosta. To my left, she's an assistant professor of technology regulation at the Tilburg Institute for Law, Technology and Society, and she's worked intensely on privacy and data protection, particularly in the new context of new technologies and health law. So I'm very happy to have her here, and she's going to talk a bit about fundamental rights requirement and the European Convention of Human Rights. We then have two more focused case studies here. One is going to come from Jo Cavan, to my right here. She's head of the British Interception of Communications Commissioner's Office, and the specialist on question of interception, communications data, and digital forensics as well, in both the private industry and government agencies, as far as I have learned. So she's going to tell us a bit about the British system of surveillance agencies supervision and how that works and the possibilities and limitations on that. We then have Anna Roth on the far left from my side. She has a long record of activities in net politics, privacy and others, and worked for the Technology Collective. But most importantly, since last year, she works for the German MP, Martina Renner, in the Inquiry Commission of the German Bundestag on the NSA activities. And so she's going to give us an insight on the possibilities and constraints of such parliamentary inquiry committees from a practical point of view, and I'm very much interested in that. And then last but in no means least, we have Ahmed Ghappour there, who's a professor at the Hastings College of Law at the University of California, where he also heads the Liberty, Security and Technology Clinic, as I have learned. And he specializes in the interplay between new technologies and national security, particularly from a constitutional law point of view. So we also have a US perspective here on the panel. So as with most of the panels, we'll have input statements and then hopefully plenty of time to discussion with the audience here as well. So I would hand over the word to Eleni, who's going to give us her presentation.
Thank you, Gerrit. Welcome, everybody. So while preparing this panel, Gerrit and Caspar asked me to try to give a little bit of oversight, a little bit of a description of what is happening, what has been happening at European level, both in terms of legislation and in terms of case law, that could be relevant for the discussion. You can understand that this has been a great challenge, and I'm not sure if I will succeed in providing you with very interesting comments, but at least I want to give you an impression of what has been happening. So it's not that we have been talking about state surveillance only since the last year and a half, since the Snowden revelations. The European Court of Human Rights has published a number of very interesting judgments in the last 30 years or so, 35, 40 years. And it would be impossible to provide you with an overview of every single case that could be relevant for the discussion that we are having today. However, I think it was very important to start with a reference to the case Class and others versus Germany, where actually the European Court of Human Rights admitted that the existence of some legislation granting powers of secret surveillance is, under exceptional conditions, necessary in a democratic society. And I want us to pay attention to the fact that although the European Court of Human Rights admitted that existence of such legislation can be acceptable, this has to be under exceptional conditions. And the court further stressed that this does not mean that the states enjoy an unlimited discretion to subject persons with their jurisdiction to secret surveillance, and required that the states put in place adequate and effective guarantees against abuse. So this has been part of an established position of the European Court of Human Rights. Another famous case, although it's not about state surveillance, but it had to do with the creation of a DNA database in the United Kingdom, is the case S. and Marper versus the United Kingdom. In this case, the European Court said that blanket and indiscriminate, the blanket and indiscriminate nature of powers fails to strike a fair balance between public and private interest. And this brings in mind things that have been discussed in the context of data retention, blanket data retention, in this conference as well, and by the European Court of Justice. And the court further required that sufficient guarantees against the risk of abuse and arbitrariness to be put in place. Of course, this is all very general, and the states had to interpret and adapt their legislation to the sayings of the Court of Human Rights. Finally, I would like to refer to the case Weber and Saravia versus Germany, which, although is not a case that has, I think it has not attracted a lot of attention because the court found that there was no violation of Article 8 and Article 10, so the right to privacy and the right to freedom of expression. However, I consider it a very interesting case because of some remarks that were made by the court. So specifically, in this case, the court said that the mere existence of legislation which allows a system for the secret monitoring of communications entails a threat to surveillance for all those to whom the legislation may be applied. Therefore, in these cases, we need to take into account what kind of safeguards and checks and balances are put in place in the national legislation. And this is something that we need to keep in mind when we talk about state surveillance today. Another case, not from the European Court of Human Rights, but from the Court of Justice this time, is the commonly known as the data retention judgment. It's a decision a judgment that was delivered in April last year, and it has attracted a lot of attention, especially in Europe, because the court examined the validity of the data retention directive, especially in relation to its compliance with fundamental rights. And the court made some very interesting remarks, saying that the data retention directive, in the way how it has been adopted, does not provide for any exceptions for the protection of professional secrecy, so lawyers, journalists, etc. Also, the directive failed to lay down any objective criterion by which to determine the limits of the access of the competent national authorities to their data and their subsequent use. So this was left completely in the hands of the European member states. And there we saw that there was a number of national court cases that actually annulled specific provisions, if not the whole laws that adopted the data retention directive in the national legislations. Provided several interesting arguments to come down to the conclusion that the way how the data retention directive was drafted is not compliant with Article 7 and 8 of the Charter. So this is the right to privacy and the right to data protection, and therefore the data retention directive is invalid. So this has been the situation until now. At this moment, I mean, you have followed a lot of panels. You know that there is the data protection directive is under review. maybe you think, why is it interesting to talk about the Data Protection Directive in the context of mass state surveillance? It is commonplace, and also it has been verified by the Court of Justice in its PNR judgment that the Data Protection Directive does not regulate the processing of personal data in relation to state surveillance purposes. However, I would like to draw your attention to this amendment of the European Parliament. So the European Parliament, in its first reading, added this Article 43A, that is dedicated to the transfers or disclosures not authorized by union law. It's a quite lengthy article, so I couldn't present you with the full text, but in short, what the article says is that when a court or an administrative authority that is not based in the European Union requires information, so makes a request to access information about European citizens, then the data controller or the data processor needs to get prior approval by the Data Protection Authority. So in simple words, what would it mean in practice? That US, for example, based companies will seek approval from European authorities in order to comply with an order by US authorities to deliver data, and this is the case if there is no mutual legal assistance treaty or another international treaty. It is interesting that the Council, so there is an unofficial document published by the Council in December. The Council does not endorse this amendment, so you will not see this amendment proposed by the Parliament in the Council's draft. This proposal by the European Parliament reminded me of the Microsoft case. You have heard about this in several other panels. I will very briefly say, for those ones that are not familiar with it, that, excuse me, that the US authorities wanted to get access to the email of a citizen and this information, so the actual content of the email and the subscriber information. So everything was stored in the database in Dublin. Normal way to get access to this information would be through mutual legal agreement treaty that has been signed between the US and Ireland. However, the US authorities managed to get a warrant under the Stored Communications Act, and there was a decision by a US district judge, a New York US district judge, that said, yes, this is okay, you can go on with the warrant, and Microsoft should reveal the information, should deliver the information to the US government. What is interesting is that the main argument was that the actual search and seizure takes place in the US when a US-based Microsoft employee queries the Dublin database, prints out and saves to a hard drive documents retrieved from the database, and hands them to the government, which is a kind of strange argumentation, because actually the US government has used exactly the opposite argument when they want to avoid the application of US legislation. So just something to keep in mind. This is a pending case in the end of December last year. So Microsoft appealed against the case, and in the end of December, the Irish government published an amicus curiae brief saying actually that they support Microsoft. Another interesting case is pending, still partially, in the United Kingdom, in front of the UK Investigatory Powers Tribunal. Maybe we can talk a bit briefly about it later on, but I wanted you to know that this is a case that was brought in front of the UK Investigatory Powers Tribunal by the Privacy International, Liberty and Amnesty International, and actually they are questioning the system of mass state surveillance that was put in place in the UK. The tribunal published a judgment in December 2014, answering partially so some of the questions, And the court said that, okay, the system of mass surveillance could be lawful, but they asked for more submissions on the lawfulness of receiving bulk intercepted material from foreign intelligence agencies such as the NSA, and it is still not decided if the whole system is justified. So we are expecting to hear more from the tribunal. Another case is more related to data retention. So after the decision of the Court of Justice, which said that the data retention directive is invalid, the UK legislator was very quick to adopt a new act, the UK Data Retention and Investigatory Powers Act, trying to make sure that they have a legal basis to continue doing retention. So 2 of the UK MPs, with intervention from Open Rights Group and Privacy International, questioned the lawfulness of the act. Yeah. So there are also 2 pending cases in front of the European Court of Human Rights that I think it would be very important to bring to your attention. They're both pending. So the first one is launched by Big Brother Watch, Open Rights Group, English Pen, and Constant Kurz against the United Kingdom. And this case mainly deals with potential interference with Article 8, so the legislation, the general GCHQ intercept on the basis of non-specific blanket rolling warrant for interception of external communications and whether this is compatible with Article 8 of the European Convention. And the latest case that was submitted a few months ago by the Bureau of Investigative Journalism of the United Kingdom turning against the United Kingdom. This is a case that does not deal only with privacy, but mainly with freedom of expression, so journalistic free expression. And there, the applicants question whether the UK legislation, and mainly the Regulation of Investigatory Powers Act, properly protects the journalistic sources and the communications from government scrutiny and mass surveillance. So there is a lot going on. We try to keep an eye on everything, but I think it's impossible. So I would be very happy to welcome anybody who reads about cases or knows about cases or initiates cases to let me know. And I think we can move on to more detailed cases by my colleagues. Thank you.
Thanks a lot, Eleni, for this oversight. And I guess next year in CPDP, we're probably going to see a whole series of panels on all those cases once they've been decided, hopefully. It's also very sad that Caspar is not here telling us now why, from a privacy advocacy point of view, he wants Microsoft to lose that case, actually, which was one of the points he wanted to point out here. We're going to move on to Jo Cavan, who tells us more in detail about the UK and maybe some thoughts on those UK cases as well.
So thank you. I'm very pleased to be here to tell you a little bit more about the work that my office undertakes. I'm the head of the UK Interception Commissioner's Office, and we're responsible for overseeing the intelligence agencies and law enforcement use of interception and communications data powers. I work to the Interception of Communications Commissioner, who's a retired Court of Appeal judge appointed by the Prime Minister. I'm going to talk a little bit about our regime and some of the judgments and checks and safeguards that have already been mentioned, how they flow into our audits and our oversight. And also I'm going to talk a little bit about the limitations of the oversight in the UK. So first of all, our regime is post facto. We carry out retrospective inspections to check that the powers are being used lawfully. We're not responsible for legislation or for policy, just for scrutinising compliance against the rules. So we have full and unrestricted access when we go into the intelligence agencies and law enforcement, and I think that's very important that they're under a duty and an obligation to provide us with all information that we need to carry out our function. We go in and interrogate their systems. We've developed our audits over the years to use technology to our advantage, and we've worked closely with some of the private companies who've built those systems within law enforcement and agencies to actually mean we can run query-based searches and go in and proactively look for compliance issues, trends and patterns. We've also got very good cooperation from the communication service providers. They provide us with data in terms of the requests that the intelligence agencies and law enforcement have made of them. And we then check that there was a lawful authority behind those requests, and that's quite an important audit function. As well as obviously looking at the necessity and proportionality justifications for each individual request, we also look at we conduct a lot of work post-authorization. So in our view, it's very important to look downstream, because at the time an application is made, a lot of the justifications are hypothetical. So it's very important to actually test whether, once the authorization's been obtained and the data or material has been acquired, how that material's been analyzed and used, whether it was used for its stated or intended purpose, what actual intrusion did result, and did the conduct become disproportionate to actually the aim that was set out. Also around the retention, storage and destruction of data, and I'm going to come on to that. And importantly, the errors and the breaches that might have occurred during the acquisition process. So in a scientific sense, we actually test the original hypothesis in the application, and through our observations as to how the data is being used and handled, we might recommend modifications or additional safeguards to protect privacy. We report on our findings publicly, and last year we made over 350 recommendations to improve compliance or improve systems and procedures. So I often get quite frustrated when it's reported that we give agencies a clean bill of health, because I think 350 recommendations is really quite far from a clean bill of health. We also launch inquiries from time to time into specific matters where concerns are raised. For example, at the moment, we're currently conducting an inquiry in relation to the acquisition of communications data to identify journalists' sources. Obviously, that has very serious implications for the protection of freedom of expression, and we'll be reporting on that inquiry in the next couple of weeks. I thought I'd focus for 5 minutes just on the limitations of the oversight. I think, firstly, one of the key roles of oversight as we see it is to provide a level of public reassurance about the use of these very intrusive powers. And I think that role, if anything, is even more important now. I think the level of trust has reduced with recent events, and there's a lack of confidence in the use of these powers. So transparency is really key. That doesn't always achieve full public reassurance, but it does help, and it's a start. And I think one of the challenges and limitations, if you like, that we face with transparency is the secrecy provisions in the UK legislation around interception. So that makes it very difficult for us to be transparent. We can say a lot more about communications data, and we do. And also we took an important step forward last year. When we produced our report, it had no confidential annex to the Prime Minister. Our full report was laid in Parliament. But I think really the law enforcement agencies and the intelligence agencies have a real role to play here now in terms of transparency. What more can they do to better inform the public about how they use their powers, and also to provide compelling evidence as to why additional capabilities might be required? I was really pleased to see a couple of weeks ago the UK police forces have actually recently announced that they're looking to form a digital code of ethics. And they want to consult widely on this ethical debate around how, on the one hand, their conduct may be deemed to be lawful, but on the other hand, is it socially acceptable and reasonable? And this policing by consent model, and I think these are innovative proposals, and it's good to see them coming through. A second area where we have limitations is around the right to effective remedy. The Commissioner and my office has a responsibility under the communications data legislation to inform an affected individual where the Commissioner believes there's been a willful or reckless failure by a public authority when they've carried out their duties. That's very difficult for us because willful or reckless isn't defined, and it seems quite a high threshold. It's also unclear if on interception there's no similar provision for a reporting mechanism. And also we can't refer cases directly to the Investigatory Powers Tribunal. They can only accept cases from the aggrieved individual. We're likely to come across these cases during our inspections, so we'd like to be able to refer them directly. In addition, it's not clear whether the tribunal could deal with complaints in relation to a communication service provider's conduct. And actually 12% of the errors and breaches that were reported in our last reporting year were by communication service providers rather than intelligence agencies and law enforcement. The next area of limitations is around statistical requirements. For anyone who has read our reports for the last few years, they'll see that we've been pushing for enhanced statistics for a number of years. And we outline in detail in our report about how the current stats are inadequate. I think it's really good to see here the Home Office recently have taken on board our suggestions and our enhancements, and those are being consulted on at the moment. And I think some of those enhanced statistical requirements, including recording the age of the data, will really help to justify data retention in the future. The last two areas I want to talk about are error provisions. And again, this is an area of where the legislation needs to be reviewed. We have a responsibility for investigating and reporting on errors around communications data. However, there's no provisions in the Interception Code of Practice around errors and breaches. It's fair to say that there is a very strong culture of compliance in the agencies, and they do bring things to our attention. But without a clear, structured process in relation to defining what an error or a breach is, it can cause difficulties. So we're working with the agencies on that. And the final thing is to talk a little bit about retention and destruction. I think there's been some considerable focus in some of the recent reports and judgments around the importance of provisions, not just to access the material, but also around retention and destruction. And this forms a key part of our interception oversight. And we conducted an audit in 2013 of all of the intelligence agencies and other interception agencies and looked at the procedures. And this audit resulted in actually a significant amount of intercepted material and related communications data being destroyed because the agencies weren't able to justify why it was necessary and proportionate to continue to retain that material. On the communications data side, there's no similar provisions, so we don't actually look at the retention and destruction of the data. I did say finally, but I've got one more, I'm afraid. And this is really around the fact that legislation was drafted 14, 15 years ago, and there are difficulties now in defining what the content of a communication is in the online environment. We've recently put some examples in a paper we published around those difficulties. And I think someone said yesterday, one doesn't need a law that mentions every type of technology to enforce privacy. And that does sound sensible to me. But then if we're not going to be specific, how can we ensure that the law is sufficiently clear about what is and isn't permitted? But I think just to close, I think in the UK we're in a really interesting time. There's a number of reviews ongoing at the moment in relation to capabilities, powers, and also oversight. And I think if everyone works together, that's civil society, telecommunications companies, oversight mechanisms, and also law enforcement and the intelligence agencies, we can come up with some proposals and some new legislation and oversight provisions that will protect privacy in an enhanced way. I'm sorry if that kind of sounds a little bit overly optimistic, but I think there are some fantastically talented people in this field of work, and I think if we do work together, we can ensure we get the clarity, the foreseeability, the adequate human rights protections. Maybe it's just because it's the weekend that I'm feeling a little bit optimistic, but thank you.
Thanks a lot, Joe, for that valuable insight in the details of your work, and also for the optimistic view. So Anna is next. Do you want to come over here? Or?
Thank you. Sorry for the short interruption here. Thanks for the invitation. I'm very happy to be here. It's my first time at the CPDP, and what I'm setting out to do is to give you a brief overview of the work of the Parliamentary Inquiry Committee we're having in Germany to investigate mass surveillance. And I think in the process I'm going to have to deconstruct a little bit the positive image that I've seen in the conference that Germany has as one of the actors of pro-privacy activities in comparison to many others, because the inside view is a bit different, and you're going to see why I have that view. So I'm going to talk a little bit about what the committee is and what it does, and then since we've not been working very long, I'll touch some of the findings that we have so far and some of the controversies, and also explain about what the possible outcomes might be and might not be. So Germany had federal elections last year in September, I believe, or late August. And that was, as we all remember, just 2 or 3 months after the Snowden revelations. I think that was one of the reasons why the German parliament and all the parties in the parliament decided to have an inquiry committee to investigate mass surveillance, and specifically the involvement of the German intelligence services in mass surveillance. On the 20th of March last year, a temporary committee of inquiry was established by the German Bundestag, our national parliament, and actually it was voted upon unanimously by all the parties in parliament. The committee, as it is now, has 8 members, and the members reflect the seating in parliament, and therefore we have, since we have a very large majority of conservative and social democrat parliamentarians who form the government. We have 4 conservative MPs in the committee, 2 social democrats, and then 1 socialist and 1 Green Party member, 8 altogether. Okay. The committee is a temporary committee which is established for the duration of the legislative period. In theory, it would be done once the task of the committee has been fulfilled, but the task of this committee is quite large, so we're all kind of expecting this to really last until the very last day of this legislative period, and the next election is scheduled to be in late summer of 2017. It has a written task which it is to fulfill, and you can see some of that here. The Committee of Inquiry should, these are the first sentences, triggered in particular by press coverage following the revelations by Edward Snowden regarding internet and telecommunications surveillance, clarify for the period from 2001 onwards. Firstly, whether the intelligence services of the Five Eyes states are collecting data on communication from, to, and in Germany, and whether the German government had knowledge of such practices, combated or possibly exploited them. Of course, the whole task has several pages. I'm not going to read all of that to you, but these are the main 3 aspects of it. Secondly, it is to inquire whether and to what extent communications data of members of the federal government, federal staff, and members of the German Bundestag was collected by the intelligence services of the states named in point 1. And thirdly, whether recommendations to ensure the protection of telecommunications and the integrity and confidentiality of IT systems and confidential communication in the state sphere are required. So these are the 3 main aspects, and then there's a number of details named in them, and the 2 that I would like to mention specifically, because they kind of stand out a little of the others, is one part that directly relates to the drone war, and whether US bodies that are actually situated in Germany, on German territory, are involved in the drone war. And of course, we are also inquiring whether the German secret services are actually involved in this, for example, by handing over data. And the other quite specific part is to what extent did the German government enable US security authorities to take part in the questioning of asylum seekers or to question asylum seekers themselves. What happened thus far? The committee was constituted in March and has taken a bit to actually define how it wants to work and to set its rules. Then in summer we started having hearing of a number of expert witnesses on national law, on international law, technology. Behind the screen, so to say, we called a number or named a number of witnesses that were to be heard. And the number one witness that the committee wants to hear is, of course, Edward Snowden. And some of you may have heard about this. There has been an ongoing, I wouldn't say battle, but struggle between the government and the committee, and specifically the opposition parties in the committee, over whether we would have the protection offered to Edward Snowden by the German government to have him safely travel to Germany to be a witness and to testify for the committee. And this is an ongoing struggle. We've taken this to the Constitutional Court because the majority in the committee, the Social Democrat and Conservative MPs, are actually not supporting that motion, that we feel that he is the most important witness. He knows the material best. He knows actually what happened, and therefore, of course, we need him. They did support naming him as a witness, but they think we could also just travel to Moscow or have a video conference or something like that, where we think that as an temporary oversight committee, if you wish, a control body of the German parliament, and in a democracy it's the parliament that controls the government, right? So it's not the government that defines what we can do as a control body. The other way around, the parliament, at least that's the theory, has all the powers to define how it wants to do its work while overseeing the government. We have not been successful with this, as you can see. Snowden is still in Moscow. We are still trying to get him to come to Germany, and we do think that the government has the obligation to provide that protection, but we are still in courts over that. Starting in August, we've had witness hearings, mainly currently focusing on the interception of cable and satellite data by German foreign secret services, specifically the BND, which is the Foreign Intelligence Service in Germany, and focusing specifically on the cooperation between the BND and the NSA. We are having ongoing debates about the definition, actually, what is mass surveillance, since, for example, the chair of the Conservative Party in the committee is quite keen to point out that we haven't seen any proof of mass surveillance yet. While we think that, but while we cannot maybe have it written down exactly how that mass surveillance is happening, we are quite convinced that what we're talking about, what we're investigating, does constitute mass surveillance. But that is actually coming down to the technicalities of interception of cables and how data are being processed, and whether that's the interception already constitutes mass surveillance, or only once the data has been stored to a device or temporarily been kept somewhere, is that then mass surveillance, or is it not? So that goes quite into detail, and actually already explains a little about why we're skeptical about the ongoing oversight committees that we do have in Germany, because none of them do have any technical capacity to actually look into these details. Other important question, did the BND pass on any raw data to the Five Eyes? We haven't been able to prove that, but we do have a bunch of documents that at least imply that something like that may have happened, and this will be going on to be a topic in what we do. And so far, we're still looking at the German foreign intelligence, and we will get onto then the Five Eyes, of course, but also we realistically think that it's going to be much more difficult to find witnesses who actually can give us some insight into what's going on, for example, in the UK or in the United States. It has been very difficult to communicate with these states so far. We also had a testimony from the Federal Data Protection Commissioner in the last session, and we will go on in many more aspects of the task of the committee. So what have we found so far? We didn't have big revelations such as being able to prove that mass surveillance and mass the data resulting from mass surveillance have been handed over and being used. We're still doing that, but there has been a number of actually quite interesting smaller findings that we didn't think we would get to, since we're restricted to what the services are actually willing to give us. We cannot, I mean, we do have legally the option to force them to hand over the material, but of course we cannot control whether this is actually the case. And then for the witnesses, also in some cases, we do have some doubts whether they're telling us everything they know, but of course there's no way of really knowing. We found what is called the space theory of the BND president, which was revealed actually by the BND, which has its own data protection commissioner, who we also had as a witness, who explained to us that there is actually the question whether data that is intercepted from satellites in space would actually fall under the German data protection laws, and specifically in that case the G10 laws, which I'll get to in a moment if I still have the time. Okay, so I'm going to be really fast. So in any case, so the BND president thinks that data intercepted in space do not go by German law, since it's not on German territory, while the Data Protection Commissioner has a different opinion, but that has been contested by lawyers and will continue to be a topic. BND agents have told us that metadata are not personally identifiable data, which I think will not hold at all. We have heard that Germans who are protected by German civil laws, of course, are not protected when working for non-German companies outside of Germany, which is also something that is a very interesting interpretation of German law. And we have seen a number of BND breaches of data protection laws, and I'm not going to go into since the limitations of time. The major issue, I think, is what we call the G10 controversy. Article 10 of the German Basic Law, which is Germany doesn't have a constitution as such, it's called the Basic Law, and the first 20 articles are the fundamental rights granted to citizens. Article 10 provides the privacy of correspondence, posts, and telecommunications, and Article 10 can be restricted, meaning surveillance can be exercised in cases of targeted intelligence and in cases of non-targeted intelligence outside of Germany, assuming that this communication has some connection to Germany. Either Germans are involved or there is a cable that starts or ends in Germany, either way. All of these would require oversight by the G10 committee. And then there is also communication that doesn't have any relation to Germany, meaning, for example, going from the United States to Afghanistan, and then the BND feels to be in the right to surveil here and intercept without any oversight. But there is a major controversy over this. We had hearings of constitutional lawyers who, including an ex-president of the Constitutional Court of Germany, say that this cannot hold at all, that civil rights are not restricted to nationality. And I think some of us probably have this feeling when the United States are actually covering the FISA court cases and dealing with this issue of whether US citizens' rights are being infringed at some points, and we have this feeling, so why is this always about US citizens? Why is not the question whether the NSA surveils everybody else also an issue here? And I feel that we are currently at a similar point when we are looking at whether the fundamental rights in the German basic law actually pertain only to Germans or also to others. But this is actually the entry point that we have into saying the activities of the intelligence are clearly illegal here. And so that's where we're going to start into further investigation. So this is some of the content that we're covering, and at the same time we have a number of procedural restrictions that we are facing that make it quite difficult to do the work that we are setting out. And I'm just going to briefly mention that some of this was also pointed out by my colleague Niels in the morning at the oversight panel. There's a huge amount of blackening of documents that are handed over by the government. Of course, there's very intense classification of documents and hearings, which will not allow us to cover any of this classified material ever in public or in in the reports later on. We have what's called the consultation procedure, meaning the German government feels that any documents that relate to the Five Eyes, not like documents by the or contracts with the Five Eyes, but any documents that cover any kind of negotiation with the UK, the US, Canada, etc., cannot just be handed over to the committee, but they need to ask the Five Eyes states first whether they agree to having these documents handed over to us, which is also a very interesting interpretation of the democratic rights of the parliament confronting the government. We have huge delays in delivery of requested documents, and again, the refusal to grant protection to Edward Snowden is a major issue. Coming to the possible outcomes, once we actually prove that there is much of this activity that is illegal, is revolution going to happen? So many, I'm asking this because people have high expectations of what this inquiry might achieve. What we're actually going to have is a report. Of course, and this report is going to have to be voted upon by the parliament, and we are having a government majority that wants to protect its own people in these services, of course. There will be recommendations to the government and probably a number of cases at the Constitutional Court questioning the proceedings of the intelligence services. But I'm afraid that real change will require more public interest and political pressure. Otherwise, the government is not going to change its behavior in that case. And I'll stop here. Thank you very much.
Thanks a lot, Anna, for that less optimistic view. And we're going to change to the other side of the ocean now. Do you want to come over, Ahmed? Do you want to?
Thank you, Gerrit. And just a quick thank you to the conference organizers and participants. This is my third CPDP, and once again, I feel very fortunate to have been invited. I was asked to speak on US constitutional considerations for arriving at any settlement with the United States. Casper's words, not mine. But from a perspective of executive authorities used to conduct intelligence gathering activities with a focus on how the US Constitution allocates power to conduct domestic and foreign surveillance, the different forms of US international agreements that may come into play, and whether such agreements might limit or bind inherent presidential authorities to conduct foreign intelligence. For those like myself with short attention spans, I've prepared a slide summarizing US signals intelligence gathering authorities for your consumption, and that's this one right here. And to the right of the, what was red on my computer and now is orange, I believe, on the slide, the dotted line to the right of that is communication inside US territory. What I mean by that is that they may be foreign communications or data that resides on servers in the United States. So it's a territorial sort of equation. On the left, you have extraterritorial communications and data. And, oh, wow, that is a very different slide than what we had, huh? Whoa, oh, all right. That is the full slide right there. And so the first tier, starting with Executive Order 12333 and extending to FAA Section 702, that is intelligence gathering authorities. And below that is law enforcement gathering authorities. So beginning with the allocation of powers, intelligence gathering and law enforcement authority to conduct surveillance are executed through a broad set of authorizing statutes that essentially carry into execution core executive powers. In creating intelligence agencies such as the NSA and the CIA, and law enforcement agencies such as the FBI, Congress has created agencies through which the president carries out constitutionally assigned intelligence and law enforcement functions. Pursuant to the constitutional command to take care that the laws be faithfully executed, the president has the power to authorize agents of the executive branch to engage in law enforcement or intelligence gathering activities in addition to those provided by statute. Focusing on the intelligence community, that is the first tier, and intelligence gathering activity, the National Security Act of 1947 and Executive Order 12333, and that is the first sort of cylindrical block on your left. And its progeny lays out various missions of the intelligence community and gives each of those missions guidance on how to conduct intelligence activities. Each department promulgates and expands on this guidance through a series of department regulations. And additionally, there are a number of internal policy directives that further refine the methods by which the intelligence community can collect this intelligence. These rules, coupled with international law, allow the intelligence agencies to operate. If given the proper mission and authority, intelligence organizations can then collect information or otherwise conduct espionage activities. These operations can be done during peacetime, pre-hostilities, or during armed conflict. So the question then becomes whether the president's instrumentality has the authority to act in contravention of international law when directed to do so. And in turn, whether the president has the inherent constitutional authority to override international law. Now, of course, this is a question that has a variation of normative answers, both under US law and under international interpretations, but in an effort to conserve time, I will seek to answer it using what I believe to be the most recent interpretation and articulation as informed by relevant policy statements and executive legal opinions and other implementing regulations. So by way of background, of course, there are two sources of international law, customary international law and treaties. In enacting the, of course, the first question is whether or not the president can act in contravention of customary international law. So enacting the National Security Act and other statutes referenced above, Congress was legislating against the background of the well-recognized principle that customary international law is part of the law of the United States only insofar as it has not been overridden by the actions of the political branches, being Congress and the executive. The idea, of course, is that while international law imposes obligations on states, it does not purport to state how those nations must treat international obligations as a matter of domestic law. In this light, executive authority is to be interpreted in light of political branches' inherent power to override customary international norms. And indeed, unless Congress places explicit limitations on intelligence gathering powers of the intelligence community or the investigative and arrest powers of the law enforcement community, the current view is that it must be presumed that Congress did not intend to derogate from presidential authority by limiting those statutory powers. So this presumption is all the more compelling, of course, when the president's foreign relations powers are implicated. That would be in the case of actionable intelligence, either strategic or tactical for military purposes. That would be the case for national security. Courts have long recognized that delegations of discretion involving the president's constitutional powers must be construed broadly, especially in matters involving foreign affairs. As for treaties and other mechanisms of international law, one question that might arise is whether Article 2 of the UN Charter binds presidential powers to the extent that this applies to notions of interference of sovereign affairs, or other principles that might implicate privacy and civil liberties. So in answering this question, I will read from a 1989 memo that's been declassified and prepared by the Office of Legal Counsel. The memo is entitled, Authority of the Federal Bureau of Investigation to Override International Law in Extraterritorial Law Enforcement Activities. The memo states, even if Article 2 were construed as prohibiting certain forcible abductions, and this is in the case of a rendition, for instance, we believe that the president has the authority to order such actions in contravention of the Charter. Treaties that are self-executing can provide rules of decision for a United States court, but when a treaty is non-self-executing, it addresses itself to the political and not the judicial department. And the legislature must execute the treaty before it can become a rule for the court. Accordingly, the decision whether to act consistently with an unexecuted treaty is a political issue rather than a legal one. And unexecuted treaties, like customary international law, are not legally binding on the political branches. The president, acting within the scope of his constitutional or statutory authority, thus retains full authority to determine whether to pursue action abridging the provisions of unexecuted treaties. For these reasons, it continues, we conclude that as a matter of domestic law, the executive has power to authorize actions inconsistent with Article 2 of the UN Charter. Now, while this memo is addressing authority for the FBI, which is a law enforcement entity, as opposed to intelligence, to conduct extraterritorial activity, specifically abductions of persons without the country's consent, it applies to, its rationale might apply to all customary international law. All customary international law, unexecuted treaties, and treaty provisions that have not become part of the US legal framework. And so I believe that it provides some guidance to the breadth of executive authority to conduct extraterritorial intelligence gathering in contravention of international law. Another question or issue might be whether the ICCPR would prohibit the executive as a matter of domestic law from authorizing mass surveillance absent acquiescence by the foreign government. The short answer is that the US does not, well, the short answer is, per the above argument that was just given, no. The slightly longer short answer is that the US doesn't interpret the ICCPR to have extraterritorial effect. Indeed, the US government has articulated this position as far back as March of 1995, when its first report was discussed before the committee in March of 1995. And I'm reading from the report now. Mr. Klein has asked whether the United States took the view that the covenant did not apply to government actions outside the United States. The covenant was not regarded as having extraterritorial application. In general, where the scope of application of a treaty was not specified, it was presumed to apply only within a party's territory. Article 2 of the covenant expressly stated that each state party undertook to respect and ensure the rights recognized to all individuals within its territory and subject to its jurisdiction. That dual requirement restricted the scope of the covenant to persons under US jurisdiction and within US territory. During the negotiating history, the words "within its territory" had been debated and were added by vote with the clear understanding that such wording would limit the obligations to within a party's territory. I will conclude my remarks there, leaving you, I'm afraid, to go on to the next slide in case it's also jumbled, leaving you for questions.
Thanks a lot, Ahmed, and thanks indeed for all the panelists. As we've proceeded in time already, I would not pose any questions myself, but just go straight onto the audience and just suggest some of the topics we could actually address. Because we've talked about the oversight mechanisms, so we could look at the comparison and the efficiency of that oversight mechanisms. We've talked about the right of third country nationals as well, and I think that's a hot topic as well. And the distinction between law enforcement and intelligence agencies, that appears to be a problem as well, and whether actually, for example, under the ECHR regime, there is any such difference, that I would be interested in as well. But I see a lot of hands over there. I think the first was Ralph Benrath, and I think I take a second one just because they're so close together.
Yeah, thanks. Ralph Benrath, Senior Policy Advisor for Jan-Philipp Albrecht in the European Parliament. Eleni, just to add one more case to your list. It's probably known to everybody here that there's a big debate now after the Paris events on introducing a European PNR system. What is less known is that the European Parliament in November decided to not ratify the PNR agreement with Canada, but instead asked the European Court of Justice for its opinion also if the agreement is in line with the Fundamental Rights Charter. So that opinion will come, I don't know how long it will take, maybe a year or so. And I think that's politically, of course, that's an important thing. We should probably wait for that opinion before adopting our own European PNR system. And then a question on the transparency aspect. Does anybody know how this case, I think Twitter has started in the US in court, is that still going on or not? Where they basically are fighting for a right to tell the public that they have not received any data requests.
Okay, interesting one. I take another one as well.
Tobias Morsches from Datenschutzraum Germany. I have a question for Joanna. You said you review the requests that are delivered to you and check whether they are lawful or not and what are the problems. But since we have seen in multiple cases, most times if big requests have lots of data subjects in mind, people are so busy checking the data, they forget to mention those to the oversight committees. So how do you make sure you get every request in your hand to review it?
Okay, so we have a specific question for Joe, and then I think Eleni is going to volunteer for the first one.
Well, I think it's a very good question. We don't actually rely on them providing us with the information and the requests. We actually go in and we have full access to their systems, and we can search those systems and interrogate those systems. So that's one way that we can assure ourselves that we see everything. Another way is some of the reverse auditing I talked about with the communication service providers. So the companies will provide us with information in relation to the disclosures they've made. We then tie those up and check that there are actually approvals. So I think that's good because it provides a reassurance to the CSPs that there was an authority in place, but it's also important because it acts as a deterrent for someone requesting data when there isn't an authorization in place.
Okay. With regard to the question of Roth, I'm not aware of what's going on with specifically with the Twitter case. But what I can tell you, you are talking about the warrant cannery situation. Okay. The debate at this moment, as far as I know, is that what is different with Twitter is that most of the information is public, and that's what makes the situation with Twitter different. So the national security agencies, intelligence agencies don't need to ask permission to get access to information about the users in most of the cases. That's what differentiates Twitter compared to other companies.
Okay, I think Ahmed is going to follow up on that.
So just on the actual case that I think you're referencing, basically what Twitter is seeking is judicial enforcement to have the right to publish the fact that it hasn't received requests, surveillance requests of a particular sort. The specific type of requests that they're referring to forbid the ISP from disclosing the fact that they got the request. So the idea essentially is to post a note that you've gotten 0 requests and to take that down once you've gotten a request. So it gets the job done at the end of the day. Currently, they are allowed to post something like a category. We've received 0 to 1,000 requests. And so they're seeking judicial enforcement to be able to state that they've received 0 requests. I think as of last week, the DOJ has moved or was intending to move to dismiss the case.
There is a German
but kudos
debate.
To Twitter, of course.
There is a German debate on that sort of reporting as well at the moment, actually. Gentleman in the front was the next one. And then I have somebody there in the back, and maybe we can take these 2 questions together as well.
Ghappour, Professor of International Law. I actually gave evidence to the Bundestag, and that was very interesting on international law. One point of clarification with regard to the position on the ICCPR is that the Human Rights Committee has issued its latest report of its conclusions, summary and conclusions on the US report, in which it strongly disagrees with the position of the United States government, saying that the ICCPR does apply extraterritorially to actions of state parties that affect the rights of people outside the country. That position is also backed by the International Court of Justice, by the way, in the Israeli wall case. So international law is very strongly against the position taken by the US government on that. And one final little point of clarification. When the United States talks about intelligence gathering as Caspar Bowden would have said it if he'd been here, foreign intelligence is a category that is much broader than just threats against national security, and it includes all kind of issues like anything of relevance to the foreign policy of the United States, essentially. So just clarify, and I have one question for Joe, if I may. If I understand my friend Ian Brown rightly, the Secretary of State has the power to issue a warrant in extremely broad wording, such as, we want to intercept all communications coming into or leaving the United States under one of the internet cables. And that would be lawful under RIPA. First of all, can you confirm that such a sweeping kind of warrant would be lawful? And would you then also add that if you had found such a warrant in your reviews, your verdict would have been everything was lawful?
Okay, as that is a specific question, again, I think the mic could walk over there and you could answer the question. I'm very happy, by the way, that Caspar is in this room, even though he's not here.
So we have two regimes in terms of interception in the UK. We have a Section 8.1 interception warrant, which covers an individual or a set of premises. And then we have what you were referring to, which is the broader general 8.4 warrant for external communications. And this has been a hot topic in the UK, and the Investigatory Powers Tribunal has recently looked at the issue in terms of the lawfulness of the Section 8.4 process. They answered 4 questions in their partial judgment that they've given, that they believed the regime is in accordance with the law, and I'm not going to elaborate any more on that other than what's in their judgment, because it's partial at the moment. But we do have in our annual report some information about how that regime works and how the tests are applied. But because of the secrecy provisions, I can't talk specifically about what we do and don't look at.
Okay, so over there, and then the mic could walk over there during
the
answer
just
then. Okay.
One note, I'm so sorry.
Sorry.
Just in my defense, not really my defense, but the slide, if it were properly formatted, because I think you're reading off the side, it should say national security / foreign intelligence, but I think that's in the other line that's somehow hidden behind something. So just, you know, and I'm glad you've pointed that out. Thank you very much.
Hello, my name is Matthias Vermeulen from the Free University in Brussels. Yeah, I'm here, I will stand up. I have 2 specific questions for Ms. Anne Roth, actually. I was wondering if other European countries would want to establish a similar oversight committee as the one you're currently working on. In your opinion, which powers would they definitely need to effectively establish their task? And then secondly, I was wondering how you would describe your current relationship with the G10 committee, and is the mere existence of your committee actually an indication that traditional oversight mechanisms in Germany didn't work before? Thanks.
Thanks. Other committees in other countries, I think that's a very good idea. I think there should be one in any country that has any doubts about whether they might be affected by mass surveillance by the Five Eyes. Yes, and I understand how difficult it is to get parliaments to do this type of thing, but I would very much encourage to have more of those, and actually it would be quite interesting to actually compare the findings if ever we got to that stage. And I'm very willing to answer any question that, if that might be helpful to even public demands for such committees, of course. The second question in relation to the G10 committee, the G10 committee is an ongoing permanent committee that exists. We are not having formal relations as such. It's another parliamentary body, or actually not solely parliamentary. There's also other experts in the committee. We are actually currently establishing more formal relations because now they have actually asked to also access the documents of the inquiry committee, because they feel actually they have some, I don't know why, my assumption is that they have the feeling this might be interesting to them. And the G10 committee is specifically responsible for the surveillance related to the Article 10 of the German Constitution, and therefore there is a number of aspects that is not covered by the G10 committee that they are not responsible for, and so I would not think that they feel they are threatened by the mere existence of our committee.
Okay, so there's a question up there and then one here in the front.
So Sharif Sadari with Amnesty International. Just want to ask kind of your opinion on the issue of transparency, and we're just kind of taking the example of the UK, although it's the same applies elsewhere, that the government has so far not even acknowledging the existence of any of these programs, completely refusing to have any kind of open conversation about any of these issues. At the same time, I mean, they are talking about introducing new powers, which seems to be just the powers that we know from the Snowden revelations that they have at the moment, or at least the kind of surveillance that the UK is doing. But within that, and whether it's the UK or the US or Germany or France or any other country, do you see any hope for accountability or any adequate supervision of what are potential human rights violations if there's no transparency, if there's no adequate transparency, or if the levels of transparency are what they are today?
Okay, I think that went to Joe again, but maybe some of the others want to follow up on transparency as well.
So I think I started talking about transparency, and I think it's hugely important, and I think we have moved forward a long way, but I still think there's further we can go, particularly the agencies and law enforcement, about what they can do to actually explain why they might need additional capabilities, and then actually providing evidence around those capabilities as to why they need them, and also providing more information about how they use their powers effectively and in accordance with the law. In terms of oversight, I think we push the boundaries all the time for transparency. We've got a Twitter account now, we've got a website, and we try and publish things on a fairly regular basis. But I think more could definitely be done, and I think it's important.
So maybe we could follow on the constitutional requirements as regards transparency, if anyone wants to follow up on that.
Just a quick note on transparency and then accountability. I think they say the first rule of espionage is never to get caught. And I think in a post-Snowden world, maybe the second rule might be when you get caught, don't be that transparent, right? I kind of, as a civil liberties advocate and a defender of folks that are incarcerated or detained, I still fail to see the idea of intelligence and transparency are at disparity. So I think there's a more fundamental issue, and states need to ask themselves, do we want to continue to gather intelligence? Do we want to continue espionage activities? It's something that every state in the world does. The United States is very good at it because they have a monopoly on communications. That's not to say that I have an opinion one way or the other, although you could probably guess my opinion. As for accountability, I would just point you to the CIA torture report and the refusal of the executive in the United States to seek any real accountability from those responsible. I personally see torture as a very bad thing, and I think the whole world would sort of universally agree, pun intended with universally. So I think that's a good sort of foreshadow for accountability measures that would ever be sought in relation to espionage activities conducted by the NSA or any other state apparatus for intelligence. It's always been that these are sort of activities that are known but unregulated, and if you get caught, you get prosecuted within the state that you get caught. And there's deniability on the other end, which is why you need secrecy. It's a whole cycle.
Okay, I have two more persons on my list, so one here and one. I would take them together. Is there any urgent request? Because the next panel is on a slightly similar topic anyway, so we can save your comments to that. And as we've eaten up our time, but as there is a coffee break afterwards, we're not endangering the next panel, but just your coffee. So I would suggest taking those two questions and then give anyone on the panel a chance for a last word on the topic. So,
hi. I'm Javier Ruiz. I work for the Open Rights Group in the UK, and it's probably well known that we still consider much of the UK framework of legislation to be not compliant with human rights. Particularly, there was one thing that I just wanted to clarify before my question, which is that the UK considers that any communication of a UK citizen that uses a US service falls under foreign communications and therefore can be requested without targeted warrants. We will fall under these 1 million people in the warrant. So that's a point. But what I wanted to ask was a very specific question, maybe to Joe and to anyone, which is actually it's a bit geeky, but it's at the moment we have a system where you can control more or less, or you can have some oversight over the intake of communications, and you have some oversight possibly over the procedures that the agents will, what's called minimization or other types of safeguards. But what we've learned from Snowden is that there is a whole processing of information, mainly done by machines, programmed by humans, but still a whole of computer processing from the moment that the whole data coming from the fiber optics, gets minimized first, and then further minimized, and then analyzed, possibly for images, for text. And we would like to understand whether you think that the current regime properly regulates, and whether you feel that you have enough oversights over those processes, between the intake and the human intervention further down in RIPA, and whether you think that that's something we should tackle. I mean, particularly in the light of cases like Optic Nerve, the program of the GCSQ, where they were taking lots of images from Yahoo webcam users to train computers on face recognition. And for example, whether that kind of activity is properly regulated and whether you knew about it, for example. Thank you.
Okay. Thank you very much. So last question on the left.
Hello, I'm Christina Irion from the University of Amsterdam. And I have a short question. Whether the intelligence privileges like the secrecy paradigm that have evolved in the context of targeted surveillance measures, and where they also make intuitively sense because would risk the success of the measure if the persons concerned would know about it, whether we are not too willing to accept that they are also extrapolated to the context of mass surveillance, because I think here the societies and the citizens should be informed that this is ongoing and what the scope of such programs are, and it's not mission critical that this information is in the public.
Okay, so thanks very much. There was another specific question to Joe, so I would suggest that you start, and then anyone else who wants to have a last remark can do that.
Thank you. So I think the authorization process in place needs to cover proportionality in two different ways. It needs to cover proportionality in relation to how the interception is going to take place technically, and whether there are less intrusive means to achieve the aim at collection, but also in terms of the downstream use and analysis of the data. And when you're talking about external communications, around how the material is selected and examined once it has been collected. So all of those elements are key. And I think that's why the downstream work we do is as important as reviewing the hypothetical considerations at the start around necessity and proportionality.
No, just
I'm not forcing anybody.
Just a very small note.
What about Ahmed? No?
Just maybe very briefly on that question, whether there is a need for more transparency and oversight. I think that's kind of obviously that there is a huge need for more transparency and oversight currently, and that we need much better oversight. As we are seeing, we can see this in our work as a committee, and I think it's quite obvious through the revelations of the past 1.5 years that there's a lot of activity going on in the intelligence services that I can say from my view, even the oversight committees that are in place weren't aware of, and so the system of oversight, even though that differs from country to country, has huge gaps in there, because the oversight committees, as they are restricted by the secrecy provisions that they have, are totally dependent on the information that is handed over to them by the intelligence services, including the technical capacities that they lack totally, at least in Germany that's the case, so they rely on the technical information given to them by the intelligence services. to understand what is actually going on, and we have seen that there is huge operations that the oversight committees had no idea about. So yes, we need much more transparency. Also, because what we can see in our committee now is that the BND is clearly, and other investigative committees in Germany have proven that, has been involved in illegal activities, and we have a good right to assume that there is something going on that is bending German law extremely, not to come down with the results of our committee right now, but that is something where either bending law or interpreting law in a way that is kind of quite outrageous to the German public, which has a need and a right to understand what's going on.
Okay, thank you.
Just one remark. I would just urge folks not to get bogged down on the past, because there's a lot more surveillance coming. And specifically, no, really, in an era of cybersecurity, what's being talked about now is how do we exchange and share network security traffic, which to me can mean anything. I'm not, again, giving an opinion one way or the other, but it's sort of frustrating sometimes to attend conferences or panels where something is happening literally right now, and we're still talking about the 702.215 distinction. Just 2 cents. Thank you.
Okay, thanks everybody. Thanks for your patience and indeed for the discussion, but see you again on the next panel in about 15 minutes. But first of all, join me in thanking my panel here, which I found very interesting.